Out so I can see my slides, the kind of cue cards for me, and help me to stay on track. Because if I digress, then I'll never get anything said that I want to say. I'm going to try to cover a lot of territory today in a short amount of time. I appreciate our speaker this morning who talked about our history, Dr. Max. If we don't know our history, then we won't know what our rights are, especially when it comes to the government. And I know a lot of folks, people from Mississippi or Missouri or Florida or somewhere, might not really understand our issues out west. But we have a completely different land system in the western United States. And this was by design. Congress actually passed two different sets of laws. So we need to know how our country was settled, what the history was, what these laws are, if we're to understand where our rights derive, where they come from. And this is something I've been studying for 27 years or so. Our whole country was founded on this principle of possession or preemptive rights, all the way back to the very beginning. And it's based on a system of land settlement that has its roots in the philosophy of a guy by the name of John Locke. And John Locke was quoted more frequently. John Locke and Adam Smith, who is known as the father of modern economics, were the two most quoted men by our founding fathers in the early days of the country and debating various legislation and everything. And this is what John Locke said. Though the earth and all inferior creatures be common to all men, yet every man has a property in his own person. This nobody has any right to but himself. The labor of his body and the work of his hands, we may say, are properly his. Whatsoever then he removes out of the state that nature hath provided and left it in, he hath mixed his labor with it and joined to it something that is his own, and thereby makes it his property. It being by him removed from the common state nature placed it in, it hath by his labor something annexed to it that excludes the common right of other men. In other words, if you came out and you found a wilderness and you cut down a bunch of trees and you skinned them and limbed them up and notched them and stacked them up and built a house, you've now, the day before, those trees were common to everybody. Anybody who wanted to could take them and use them. But now that you have mixed your labor with that resource, you have now affixed part of yourself to that object. You have now created property, and you have the right to use force if necessary to protect that property. If you came out, settled on a piece of ground, you marked out the corners, you started plowing it, you started improving it, you developed it, you've mixed your labor with that land, you have created property. And this runs like a consistent thread through all of the land laws of the United States. This Lockean concept of mixing your labor, your time, and your effort with natural resources predates the Constitution. It runs like a consistent thread through all the public land laws of the United States, and thus having established this right of possession in the land, the Supreme Court has said, and Congress has consistently followed this, you had what was called a preference right, a preferential right to acquire the title to that land above anyone else. And this was followed throughout all the public land laws, all the homestead laws, the preemption laws, the desert land laws, reclamation law. Every law that Congress passed for disposal of land in the history of the country is based on this premise. This quotes from the Constitution. Article 4, Section 3, Clause 2 says, the Congress shall have power to dispose of and make all needful rules and regulations respecting the territory and other property belonging to the United States. This was a power exclusively granted to Congress. The President or any officer of the executive branch, including Secretary of Interior, Secretary of Agriculture, not even the President himself, had any power to dispose of public land. It was completely vested, according to the Supreme Court and based on the Constitution, in Congress. So when Congress passes a law and they say, if you go out and settle on the land and you improve it and you live there 5 years, you have earned it, it's yours. If you can show that you've done that, then it's yours. The issuance of a patent at that point depended on what was in the law. Congress had passed laws that said, settle on the land, file affidavits, live there 5 years, go in and pay your final fees, and then you'll be issued a patent. Or, such the Act of July 26, 1866 simply says, the right-of-way for the construction of highways over the public lands is hereby granted. And the Supreme Court said that's a statutory grant. Since Congress has this power to dispose of the land, they can do it any way they want. They can either grant the entire state, they can grant an easement, they could grant simply the mineral rights, they can grant water rights. There's all kinds of things they can do, but this power is solely vested in Congress. And so they passed a whole series of laws, and as the settlement of the West progressed, for 140 years, Congress enacted hundreds of statutes for disposing of public lands, to the states, to railroads, Indian tribes, to bona fide settlers and occupants, to miners in the actual possession of the land, under what was called a classification system. And the land was classified. It was either timberland, or it was grazing land, or it was agricultural land. Excuse me, it was agricultural land, timberland, or mineral land. Those are the three broad categories. And under agricultural could be either what we in the West call dry land farming, or it could be irrigated land, or it could be grazing land. And those were the five classifications of land that all the land in our country was disposed of after the original 13 colonies under this system, this classification system. But you'll see as we get farther in the progression of the settlement of the West, this classification system started to fall apart. When you're in the eastern United States, where there's plenty of rainfall, a guy could make a living on 160 acres or 320 or even 640 acres. But as you got farther west and you got to the arid region of the United States, that system didn't work anymore. So they started passing other laws like the Desert Land Law, the Reclamation Law. So when did public lands become split estates? Okay, Congress, when they got to this point where the land was no longer where they could classify it as clearly agriculture or clearly timberland, a lot of places in the Black Hills you can say, well, can you grow a crop on that land? Well, not really. Is it timberland? Is it mineral land? That's when the classification system started to fall apart. Okay, the land no longer fell easily into these categories. This is what the Supreme Court said. Most enduringly, public lands have been defined as those lands subject to sale and other disposal under the general land laws. Okay, so it had to be open, unenclosed, unoccupied, vacant land. Essentially, think of a wilderness. Because the very moment a homesteader moved onto that piece of land and staked out his corners and started to improve it, what happened? He has now mixed his labor with it. That land became segregated from the large class of public land and was now something other than public land. It was what was called entered land. And this is terminology used consistently through all the land laws. An entryman was someone who was an actual settler, somebody who had moved onto the land and started to improve it. And the very moment that piece of land, even before a patent was issued, the very moment that settler moved onto that land and started to improve it, it was now entered land. It was no longer public land. This right of possession was so important and so key to establishing rights of property that this pattern was followed through all the land laws. And between 1898 and 1916, Congress adopted a split estate policy. The reason is you got farther west, and especially west of that 100th meridian. At that point, 160 acres was no longer enough. 640 acres was no longer enough. It wouldn't support a family. But Congress did not want to give more than 640 acres because there could be valuable minerals under that land that Congress wanted to have developed. And so instead of giving a guy 160 sections of land, which he might not be interested in developing the minerals, he might not be interested in developing the timber. And so Congress decided on this split estate policy. And they had to change the definition of the term public lands, because now they started, instead of disposing of 160 acres, which included everything from the center of the earth upward through these four corners and up to the heavens above, and everything within that 160 acres was what originally they disposed of. Now with a split estate, they were disposing of the surface, keeping the mineral estate, keeping the commercial timber, and so now public land, the term public land, did not apply to simply land. And so Congress changed the definition. Here it says public lands, and this is out of the Federal Power Act of 1920, public lands means such lands and interest in land owned by the United States as are subject to private appropriation and disposal under the public land laws. Okay, so under the mining laws, you could still enter this land, go onto this land, even if someone already owned the surface, because the government had retained the minerals. And so you could enter onto that land, a miner could, to explore for minerals. They could get a lease under the Mineral Leasing Act in 1920, or they could claim under the hard rock mining laws, or if it was within a forest reserve, they could actually harvest a commercial timber, put in an application for a commercial timber sale. So the West developed into this split estate. Here's what the Supreme Court said as early as 1879. It's well settled that all land to which any claim or rights of others is attached does not fall within the designation of public lands. Okay, why? Because it's no longer open entry and settlement. Someone else has already settled there. So even though the legal title might be in the United States, because a patent had not yet issued, yet that was no longer public land because no one could settle on it. So it's important to understand these definitions. And that's a couple of things that I made some notes on that I wanted to make sure that I did not forget to bring up today. And that's definitions. So if you're taking any notes, which there might be at least one person maybe taking notes, the terms that you need to remember out of this today would be the term public lands, allotments, and permits. Okay, because there's a difference. These words all have meaning in the law. And I appreciate Dr. Max this morning talking about our history, because there's three things that we need to know today. We need to know our history. We need to know the meaning of the words in these laws. And we need to know who our enemies are and who our friends are. And I'll probably go off my slides here in a couple of minutes. But first, I want to get through these definitions. Okay, this is a case, Atherton versus Fowler, 1877. This was a case where a guy thought he owned the land. He had, in California, he had bought part of what was assumed to be a Mexican land grant. It was later found out that that land grant was invalid. All the right people under the Mexican government had not signed off on the grant, and so therefore technically the legal title was still in the United States. And so overnight people started moving on to his land and filing homestead claims, and it went all the way to the U.S. Supreme Court, and the Supreme Court said no, those guys cannot do that because it is not public land. The mere fact that the government owned the underlying title, legal title, it was not public land. This guy had taken possession of the land, he had improved it, he had mixed his labor with it, he had created this right of property. He was in possession of this land and had been for many years. And so this is what, and one of the homesteaders, it took them a year to get the government to get these homesteaders off, and one of the homesteaders had cut a bunch of hay off of the land and sold it. So he took them to court to recover for the value of the hay. And it went all the way to U.S. Supreme Court, and this was what the Supreme Court said. It follows that the later settlers could not have made any lawful entry on the lands where the hay was cut in this case, that no law existed which gave them any right to make such an entry, that they were mere naked trespassers, making an unwarranted intrusion upon the enclosure of the earlier stock raiser, an enclosure and occupation of years, on which time and labor, he had mixed his labor with the land, time and labor and money had been expended, and then in such a wrongful attempt to seize the fruits of other men's labor, there could be no bona fide claim or of right whatever. The instruction of the court that this could be done, founded on an erroneous view of the preemption law, was itself erroneous, and the judgment founded on it must be reversed. So Atherton won. The guy that was the rancher that had thousands of acres of land, far more than you could get under any of the homestead laws, and the Supreme Court said it didn't matter. He had settled the land, he'd enclosed it, he'd improved it, he had created a right of property. And therefore, the homesteaders could not settle on it. In the case, it further went on to say that the agents of the land department, which was the Department of Interior, had an affirmative obligation to protect his rights, to not allow anyone else to go on there and even settle on that land. This was an important case. This became known as the Atherton-Fowler Doctrine in all of the decisions of the Land Department from that point forward. Let's see here. So, Congress passed a whole series of laws from beginning in 1866. It recognized improvements and water rights. And so forage in Atherton versus Fowler, this was improved. The court said it was improved because he had fenced it in and he had a rotation grazing system. He'd improved the forage. So forage is an improvement, not just fences and corrals, but the water rights are improvements also. And Congress had passed a whole series of laws recognizing these improvements so that the actual settlers of the West would be protected in these rights. I'm going through some of these slides a little quicker. So what is a split estate? A split estate is anything where you don't own everything from the center of the earth to the heavens above. So that's basically most of the United States nowadays. Because somebody else owns mineral rights, there could be right-of-ways, there could be easements, there's all kinds of fractional interests but yet it's considered what's called real property. And there's a difference between real estate and real property. Real estate is an area of land. It's got a GPS location, a legal description, the southwest quarter, section 6, township, whatever. Okay, that's real estate. Real property are the fractional interests, such as oil and gas rights, hard rock mineral rights, the surface rights, water rights, okay? And the West exists essentially in a split estate because of this series of laws that Congress passed. Now, if you're taking notes and you want to, here's 4 cases you can read. If you want to go back and you say, man, I've never heard this before. I don't understand. I thought everything was public land. Let me ask you this. Can you settle? Is there anywhere in the West where you can go out and homestead today? No, you can't. There is no public land. It's a myth. And this term public land, we need to learn the actual meaning of the word, the actual definition, so that we can begin using the right terminology. The bureaucrats want you to call it public land. The environmentalists want you to call it public land. Because if you go into court arguing with the judge over public land, he has to go by what the legal definition is. Okay, and the legal, on public land, there are no rights on public land. It's open, vacant, unoccupied, unimproved. That's public land. Is your ranch public land? Is your allotment public land? That's one of these words that you need to know the definition of. Public lands, allotments, and permits. You need to know the difference. Because an allotment is not public land. Is a reserved mineral estate public land? It is. Based on the definition Congress put in the Federal Power Act, it is land and interest in land. So reserved mineral estate is technically public land. Reserved commercial timber in a national forest is public land. That timber is public land because it is an interest in land. Okay? If you think, oh, Angus, you're full of crap, go read what the Supreme Court has said about this. Watt versus Western Nuclear, 1983, talks all about this government policy that culminated with what's called the Stock-Raising Homestead Act in 1916. This policy occurred between 1898 and 1916. All of these laws, Congress passed a dozen laws in that time period which fully adopted the split estate policy for the West. Okay, so Watt versus Western Nuclear, you can go to a website called Justia. Justia.com, go to that website. In the search block, type in Watt versus Western Nuclear, 1983. It'll pull it up. It's got all the Supreme Court cases. California versus United States, 1978. United States versus New Mexico, also 1978. Kinney Coastal Law versus Kiefer, 1928. That was the first split estate decision the Supreme Court made. So the nature of the land in the West was so physically different, Congress established two different settlement patterns. This is where you can find all these laws. Title 25, Title 43, Title 22, Chapter 22 of Title 43, and Title 30, Mines and Minerals in the United States Code. You can look up all these laws. Now, why is this that they adopted that? Because right where the 100th meridian is, that's a 30-inch rainfall zone. And even in the 1800s, Congress knew that west of that line, you could not grow crops on any reliable basis without irrigation. So the riparian doctrine applies in the eastern United States. There are two water doctrines, and in that case that I told you to write down, California v. U.S., you can read about it. Justice Rehnquist gives a very succinct, very good history of the development of water law in the United States. There's two different doctrines of water law in the United States. Now, the states that are bifurcated, divided by this 100th meridian, North and South Dakota, Nebraska, Kansas, Oklahoma, Texas, the Supreme Court said it's up to those states to choose what their water system is going to be. Kansas, I know for a fact, the entire state of Kansas is under the prior appropriation doctrine. Nebraska has two different systems. In the eastern part, they go by the riparian doctrine. In the western part, they apply the prior appropriation doctrine. So it just depends on those states. But the riparian doctrine had its origins in Eastern law. Under the riparian doctrine, anyone who owns land along a water course has an equal right to everyone else. What time is it, Kathy? You know? 12? Okay. So I'm about halfway. I need to be halfway through, so I'm going to speed it up. This is a map from the United States Code. These are all what are called waters of the United States. Have you heard that before, WOTUS? Waters of the United States, guess where that comes from? It comes from the government's constitutional authority to regulate interstate commerce. These are all the navigable rivers of the United States. There's none in the West. Look where that 100th meridian is. Even Congress knew that back in the 1800s. The only two navigable waters in the West is the Columbia River from the ocean to the Idaho border and the Sacramento River. Okay, that's the only navigable waters in the West. Okay, so that's why there's this two-tiered or split system of water rights in the United States. It's reflective of the difference in the United States between the East and the West. So Congress, starting with the Act of 1866, 1870, and the Desert Land Act, the U.S. Supreme Court said that those three acts together severed all the water in the West from the federal lands, from the public lands, and made those waters available for appropriation under state law. Okay, here's all those other laws that I was telling you about. We don't have time to talk about them all, so we're just going to skip over them. The fact that ranchers pay a fee confuses people and makes them think they're leasing their allotments. You are not a leasee. You're not renting anything. You own your allotment. Okay, and the word allotment, the Supreme Court has said, is analogous to the word homestead. They mean the same thing. It's an actual apportionment. It's defined in words and phrases as an apportionment of land to someone who by right is entitled to it. Okay, and who has the power to dispose of the public lands under the Constitution? Congress. So when Congress passes what's called a Relief Act, it cures all defects in title. And in 1923, you'll see as when we get there maybe, in 1923, Congress passed a law that cured the defect in title of any ranch that existed in the West at that time. Okay, it was called an Act for the Relief of Certain Settlers. And Section 1 applied to everybody who was in a national forest. Section 2 applied to everybody that was outside a national forest. So it covered everybody. All right, but the whole purpose of Congress at this point in time was to settle land titles. The only reason they limited the amount of land you can get under the homestead laws was because they wanted to develop the minerals as well. Well, once they adopted in 1910, by enactment of what's called the Pickett Act, once they adopted the split estate policy, then in 1923 they passed this law that called, well, it's just called the Relief Act, and that settled all land titles in the West. But as far as fees go, fees have nothing to do with the ownership of the land. Fees have to do, grazing fees go for three things. 25% goes back to the state and county of origin for roads and schools in lieu of taxes. 25% is an administrative charge because all the wonderful services the Forest Service and BLM provide to you. And the other 50% goes into what's called the Range Betterment Fund. And that's a separate fund in the Treasury. It does not go into what's called the general fund. It goes into a separate fund, and that money can only be used to build improvements on your allotment. Now, that's what the law says. I'm not saying, and people say, oh, I haven't built improvements on me for 20 years. I'm just telling you what the law says, okay? If you believe that these federal employees are obeying the law, you're deceived, okay? All right, so here's, there's 20 different Supreme Court decisions between 1877 and 1918 in which the U.S. Supreme Court said range rights are property rights. 20 decisions of the U.S. Supreme Court. Here they are, okay? So how did all these laws come together? All right, you have a homesteader. He takes up a 160-acre homestead. He populates the range with cattle. They water in this creek and at these springs. There's at least 3 property rights illustrated here. You got range rights, you got water rights, and you got your base property. Okay, all recognized by acts of Congress. The Act of 1866 recognized easements for ditches and canals. So this homesteader starts developing all these ditches, pipelines, flumes. He drills through the ground because the Desert Land Act, he even severed the groundwater from the land, brings the water to service, develops a well. So then you got the Livestock Reservoir Site Act that granted a 160-acre easement around every stockwater location. So now you get easements. Okay, the act, you had a right to enclose your range because you had what was called color of title, recognized under state law. And so in 1885, Congress passed, the name sounds almost opposite of what it was intended to do, but it's called an act to prevent the unlawful enclosure of the public lands. Well, what it really authorized was the lawful enclosure of entries, land that people had already settled on. They were authorized because the Supreme Court had recognized, also you had right-of-ways for roads. This was a statutory grant under the Act of 1866. The state law, those 20 different laws that I showed you, for example, in Idaho, Nevada, and Arizona, they had what they called a 2-mile limit law. Their range laws were slightly different. But under Idaho, Nevada, and Arizona, under the 2-mile limit law, no one else could graze within 2 miles of your water or a homestead. So now you start imposing all these laws, and you see that by 1916, this is the law as it existed in the West in 1916. Nobody could go out there and settle anywhere on there. Nobody could homestead there. The only person the government could give the title of that land to was the person in the actual possession of the land, the people who had already settled there and improved the land. They were the only people that could get title. And so Congress debated from 1898 to 1916, when they finally passed the Stock Raising Homestead Act. They debated on, well, how are we going to dispose of this? And Teddy Roosevelt in 1910, in his address to Congress, it was actually in 1909, his annual address to Congress, State of the Union address, they call it now. He says, the only way we're going to dispose of this land in the West is as a split estate. So as a result of that, Congress passed the Pickett Act, which created a split estate in all national forests, and it granted to the president authority to withdraw other land and classify it as grazing land. And so under the Stock Raising Homestead Act, Section 8 of that act, there was no acreage limitation. The reason is there's no acreage limitation as to how much land you can enter under the mineral land laws, because the Congress doesn't care how much of the service you have as long as they kept the minerals. Okay? So under the mineral land laws, that is how all these ranges became perfected. Is in 1923, Congress said, okay, we're passing this act. It's going to perfect title to all this land. Now, some people say, well, you have to have a patent before you own land. No, you don't. Congress can dispose of land any way they want. And the Supreme Court has said when Congress passes an act that does not require that a patent be issued, then even if the Secretary of Interior wanted to issue a patent, he couldn't. They can only do what Congress authorizes them to do. And they said in that case, an official government survey map is title evidence. So an allotment map, official allotment map, issued by the government was considered the title document. Okay? So I'm going to speed on through here. Okay, so now I want to talk about, I was wanting to talk about endangered species. So first I had to get through the fact that an allotment is private property. Okay? It's a surface estate separate from the minerals. Okay, so when the government talks about public land, knowing what the definition of public land, it's land and interest in land owned by the government. That's what the government retained. And that's why the only kind of entry, the only kind of entry you can make in a grazing district or a forest district is a mining claim or an oil and gas lease or a timber sale. You can't homestead there anymore. Why? Because the rancher already owns it. These ranches have been bought and sold for the last 100 years. How can that happen if they didn't already own something? So the logic test tells you that, well, gee, I guess it must be private property. Okay? Or if it wasn't, you could just walk into the local BLM office and say, I want to put cows out there. What are they going to tell you? Well, no, that's so-and-so's allotment. You go talk to him. Okay? So to understand all these laws, you have to understand that they're talking about split estates. All right? And when it comes to endangered species, Congress passed the first Endangered Species Act in 1913, and it was pretty promptly after that held to be unconstitutional. Okay, the Migratory Bird Act in 1913. It was held to be unconstitutional by, in the case of United States versus McCullough. They said that the state owns the wildlife, not the federal government. Okay, so then in 1920, there was another case, Missouri versus Holland, and this time the act and treaty were upheld based on the premise that only migratory non-resident species were affected, because these geese would fly from Canada, a foreign country, to Missouri, and then the next day they might fly down to Mexico. So because they were non-resident migratory wildlife, they felt the federal government under the Interstate Commerce Clause had some power over that. So the Endangered Species Act has actually been around, and it's gone through about 5 different iterations. One in 1934, 1946, 1956, 1966, and then the famous one, 1973. So this isn't a new law. And in every one of these statutes, now you have to read laws in what's called para materia. In other words, laws that are on the same subject have to be considered together. So these other laws, previous laws, were never repealed. Any later statute passed simply becomes additive to the previous statutes. So reading all of these laws together in the Endangered Species Act, the conclusion is that government, under the Fifth Amendment, it says, private property shall not be taken for public use without due process and just compensation. So government cannot just simply pass a law and say, okay, we're going to protect sage grouse now. Okay, if they come to you and say, and that's fine, they can pass that law. But when they come to you and they say, Mike, you have to mark out 50% of the forage on your ranch, and you have to allow sage grouse to eat that, and you can't graze it. Now there is a taking of private property. And even under the Endangered Species Act, government cannot take your property without paying you for it first. Okay, so sure, they can declare a sage grouse endangered. That's fine. But when they come to you and say, oh, you can't use your property now, you have to pay us for it. Okay, and some of you might be thinking of John Duarte out in California. That wasn't an Endangered Species Act. That was Waters of the U.S. Act. And they fined him $1 million because he plowed a wheat field where he supposedly plowed wetlands. Well, his attorneys started out wrong because they didn't challenge the wetlands designation. Okay, wetlands are swamp or wetlands that are immediately adjacent to the main stem of a navigable waterway. Remember the slide? It had all the rivers. Okay, those were navigable waters of the United States. Immediately adjacent to that, if there's a wetland, that falls into the wetland designation. The problem is with these bureaucrats. The bureaucrats, you give them an inch, they take a mile. I could dump out a pan of dishwater here, and they'd call that a wetland. Okay, the problem is we let them get away with this. We have let them get away with this for so long. We need to know who our friends are, who our enemies are, and we need to stand up. Spike Goss reminded me of something this morning, and did Jesus compromise? When Satan came to Jesus after 40 days in the wilderness and he tempted him, did he compromise? He didn't compromise. And that's been our problem. We've been willing to compromise. And we need to say no. So whether it be Satan himself or a bureaucrat, one of his minions, okay? We cannot compromise. We need to know our rights. We need to stand up for our rights. And people say, well, Angus, you know, that's dry and that's boring, going over all those old historical laws. And it is. But if we don't know our history and where our rights come from, then how are we going to fight these bureaucrats? So by knowing our rights, knowing the law, we can win. And I can tell you right now, there are lawyers that have seen my presentation, and they've come up to me after and say, man, I didn't know all this. And I said, take this information and you go and you check it and you read it. And if I'm wrong, you call me back and let me know. In 16 years that I've been teaching these seminars, not once has anyone ever said, well, Angus, your interpretation of this law is wrong. I've gone back and read this and you're wrong. Because I'm not wrong. Terry Padilla, the Forest Service lawyer for Region 4, has seen my presentation 5 times. And Todd McFarland, an attorney friend of mine from Utah, and I went up to him after one of them. We said, okay, Terry, you've seen this a couple of times. Said, are we wrong? And he said, and he thought for a second, he says, no. He says, you're not wrong. He said, that is the law. But we've been doing it like this for so long, the law doesn't matter anymore. So that's what we're fighting against. And we need to know our enemies. And there are people going around right now in the West telling, I'm going to skip ahead. You know, the law is on our side. This is out of the Federal Land Policy Management Act. Title VII, an entire section of the law. And do you know where this is in the United States Code for any attorneys that might be in here? Nowhere. It doesn't exist. When people tell me, oh, the United States Code is law, it is not. The statutes at large are the law. The Justice Department chose not to put this in the United States Code, but this is the law. And this is what Congress said. All actions by the Secretary concerned under this act shall be subject to valid existing rights. Okay? This is out of the National Forest Management Act. Any revision in present or future permits, contracts, and other instruments made pursuant to this section shall be subject to valid existing rights. But if you think that you are grazing on the public lands because the government has given you a piece of paper, a permit that says you can, then I guess you don't have any rights. You have to know what your rights are. You have to know the law. The fact is, everything, they pass these laws that say, oh, we're going to do this, we're going to do that, we're going to do this, and then they put in a savings provision like this that says it shall be subject to valid existing rights. Go look at every one of these monument designations they've made. Every single one of them was made under the Pickett Act. Okay? Or the Antiquities Act. Those 2 acts. But every single one of them has a phrase in there that says, subject to valid existing rights. The problem is we don't know what our rights are. Nobody has done the research to find out what your rights are. Until, well, I have. I spent the last 27 years doing it. Okay? But if you want to listen to some of these attorneys that claim to be our friends, okay, and I've known a lot of them for a long time, almost 30 years. And I've debated whether or not to mention names. But I have to, because there's one person from Wyoming, and she's claimed to be the friend of the rancher. And I have nothing against her. And we've been friends for a long time. But she's nominated or has been interviewed to be director of the BLM. And she has told me, Angus, I don't think ranchers have any rights. When I know that they do, and the law says that they do, and the Supreme Court says that they do, but we've got someone that is steeped in the mythology of public lands, the fake news, the lies. And we can't let those people be put in a position when we have. I think this is our last chance. I think this is a president who will stand up for property rights. I'm not getting political here, so Dr. Max, wherever you are. Okay, I'm not making a political statement, but I'm saying we have a chance with this new administration. And it's got nothing to do with Republican or Democrat, but we have a chance, and we need to take advantage of that chance and make sure that people that are friendly to our industry are who put in charge. Since 1976, we've lost 60% of the allotment owners in the West. Over half of the allotment owners have been pushed off the land. That is a fact. There's no theory, there's no opinion, it's a fact. So where are these organizations like NCBA and the Public Lands Council, which is a surrogate of NCBA? 90% of the PLC's budget comes from NCBA. So to try to tell me they are not part of the NCBA. The executive director for PLC is also the public lands coordinator for NCBA. Tell me they're not one and the same. And for the last 40 years, we've lost 60% of our allotment owners. They are not our friends. We need to know who our friends are, who our enemies are, and make the distinction. And I'd be more than happy for them to repent and join us. But I don't see that happening today anyway. And so I just want to close by saying that when you look at this map, what this is, I did not make this map. This is a Bureau of Land Management map. Okay? This is their map. And the title says, Federal Public Land Surface and Subsurface. Tell me they're not talking about split estates. We just don't, most people are going to look at that map and it's going to mean nothing to them. But the fact is, they don't own all that red. They may own the mineral estate, and some of that they may own everything, like I'm talking about national parks, things like that. But every grazing district and every national forest is a split estate. So they may own the minerals, but they do not own the service. And we need to know the law if we're going to protect our rights. Because guess what? These 17 western states right here, from here west, and Missouri, Iowa, and Wisconsin, 90% of the beef cattle in the United States come from those 20 states. So is the West important to the livestock industry? You better bet it is. And when they look at this map and they say, oh, the government owns all this land, we can kick people off anytime we want. So what happens if they do? Now you got your big four packers that say justify bringing in foreign beef. Oh, we have to bring in foreign. We can't produce enough. The people wanted to get rid of all the cattle off of that land. The people wanted it. Isn't that what they say? The people want to do it. But you know what? If the people want to do it bad enough, then they can pay you for your land. Pay you for your allotment. Because you know what? These allotments have a value in the open market. And the reason they do is because they're property. It's a split estate property, but you need to understand this concept. These are not public lands. They're split estate lands. And they may own the mineral estate and they may own the commercial timber, but the rancher owns the service. I don't know how close is, what time is it? I got 5 minutes? Okay. So conclusion, federal range policy analysis reveals congressional intent to grant split estate property rights. The Constitution, Congress, and the courts have held states own and control resident non-migratory species. The federal regulation is limited to interstate commerce and treaty regulation of non-resident species. And the feds must pay for land, waters, or interest in land. And that's under these various Endangered Species Act that I showed you. Okay? I just want to put this quote up here from our newly appointed U.S. Supreme Court Justice, Neil Gorsuch. This was a split estate ranch case that he heard in 2014, just a couple of years ago. So I'll let you read it for yourself. But he understands this concept of split estates. We need to start making the right argument so we can get these cases in front of judges who know the law. Thank you. Yeah.
Reagan, in his term, commissioned a study for the privatization, and they came back and said the federal government couldn't sell most of it. They didn't own it in clear title. Is there, surely there must have been an actual, some kind of a record of, by legal descriptions or whatever, to identify those, because I'm thinking if a guy could do a FOIA for your allotment,
Right. Her question was, when Reagan came in, there was a push to sell off some of the federal lands. And they did a study, and they came back with their report, and they said, oh, we can't sell these lands because we don't have a clear title to all this land. And so she was asking, is there some place where there's a record of who owns what? And yes, there is. It's in the Department of Interior in Washington, D.C. These allotment maps are official government surveys. And the original allotment maps for all of these allotments is kept in, I'm trying to think of U.S. Geological Survey. That's who keeps them. They have the record in Washington, D.C. of every one of these allotment maps. Okay, because that map is an official, there's two government title documents, a patent or a survey map. And because all these allotments and these ranges had to be mapped according to what's called meets and bounds, they couldn't be described by a legal description, so it could not be put into a patent. They had to be done by a survey. And there's several, I'll give you some cases. If you want to write it down, Shaw versus Kellogg, Stone Road versus Stone Road, Hosmer versus Wallace, and Jones versus St. Louis Land and Cattle Company. Those are all Supreme Court cases that talk about this issue of a government survey map being evidence of title, and that you don't need a patent. A really good case is Morrow versus Whitney, which was I want to say 1885 Supreme Court case. And they explain how when Congress makes a statutory grant, they don't have to issue a patent. A patent would be nice. All it would be is just further evidence, but the official government survey and the grant from the act of Congress itself is the evidence of title.